See, the best place, one place to be as well, so that's fab, and London as well. So fab. So I'm going to hand over to Marie and Paul, who'll take you through to today's subject, which is part 2 of the TUPE series from Marie.
Okay, thanks Richard. So hi everyone, it's good to see everybody logging on. I can see people joining us as we're talking now, so I'll just do a bit of an intro. So I'm here today with Paul Wilson. He's a barrister at St Philip's, and that's a chambers, and they've got chambers all around the country now, so they're quite a big set. We had a previous webinar that preceded this with one of his colleagues, Mr Frew, and that was basically TUPE the basics. And this now is TUPE without tears. So basically this is some common pitfalls and some things to look out for and how to avoid problems with TUPE. We've got quite a lot to get through, but we're happy to take questions and answers. If you want to send us your messages anonymously, that's absolutely fine. Just send it to us. If you want everyone to see it, that's fine. What we normally do is, if you've got a question, it is normally relevant to the group as a whole, and we can answer it throughout the webinar. We can answer it at the end of the webinar when we're not live and being recorded, or we can answer it if you contact us directly after the webinar, and you will have the contact details sent to you. So without further ado then, I'm going to hand over to Paul, who is doing the lion's share of today's webinar. So over to you, Paul, TUPE without tears.
Thanks, Marie. I'm just beginning to regret the title of this talk, TUPE without tears, because I think but the more I look at it, I think you're almost guaranteed to have tears if you've got any dealings with TUPE. And on that ominous note, I begin. What this talk is really about is to look at, as Marie says, some of the common pitfalls that it seems to me we're capable of falling into when we're dealing with TUPE matters. They're born out of my experience, and I mean, I invite Marie to chip in. My experience as a barrister is often, as you might imagine, coming along after things have already gone seriously wrong. I think, Marie, you'll be more coming from the direction of looking at things as they're developing and trying to think of a solution as matters develop. Mm-hmm. So we're sort of, we've got different viewpoints, and hopefully we can agree on in the middle. Now, I'm going to begin with one major overriding issue, which it seems to me is almost invariably lurking at the bottom of any problem that ends up in the employment tribunals due to TUPE, and it's simply this. It seems to me that employers, transferors and transferees, as it were, in a TUPE context, regard it all too often as a series of unpleasant hoops and obstacles to be jumped through and run round, and as a major obstacle to progress in a business transaction situation. And it seems to me, coming at it from an HR employment law perspective, that's the wrong attitude to take. And just going on to my first slide, what I think you need to bear in mind is this, and try and what I'm really saying is try and become a poacher turned gamekeeper here, because the effect of the regulations, you shouldn't forget, is to give effect to the general purpose of the EU Acquired Rights Directive and the Transfer of Undertakings Protection Employment Regulations 2006, as they're lovingly called, which is to safeguard, as my slide says, to safeguard and preserve employees' rights on the transfer of a business or on a service provision change. Now, just thinking about that, the idea is that if you're an employee caught up in such a situation, you're pretty much going to have the same employment rights after the transfer as you had before the transfer. Now, you might think, well, that's pretty obvious, Paul, thanks for that. The reason why I'm pointing this out to you, I think, is it's all too often to forget about it. And you see, if you have the unfortunate, the misfortune, should I say, to end up in the employment tribunals with this, the thing to bear in mind is that is the attitude the courts are going to take. You're going to get a purposive construction of the regulations. The tribunals are going to be looking at, has what you've done achieved that purpose? So if you start thinking in those terms from the very beginning, it seems to me you're going to give yourself the right steer when it comes to dealing with any TUPE issue. Okay, so I've sort of flagged that up as a major issue right at the beginning. Let's go on to deal with a few more issues. I think it seems to me one major issue, this is perhaps more a case of small to medium-sized employers. It's just simply failing to identify when TUPE applies. And just rolling through my slides, I think some of them we probably don't need to dwell on in too great detail.
Well, I think this was covered, sorry to interrupt you, Paul, some of this has been covered by Mr. Frew in the first webinar, so we can go through this quite quickly.
I'm sure we can, Marie, I'm sure we can. I mean, really, all I need to say about this slide about business transfers, obviously you will appreciate that some pretty complicated issues of employment law can arise from these issues. I think it's pretty obvious, isn't it, when in the situation where one business is selling a part of its business to another business, obviously you'd be mad not to realise that TUPE applies. So business transfers, dead easy. Those are the questions that might arise if you need to think about whether TUPE actually applies. Let's roll on, look at what I really want to say about this issue. It's got to be a transfer to another person, another legal person, as you might realise. And I think what I'm really wanting to bring home is how wide-ranging the effect of TUPE is, and it just doesn't apply to the ordinary sale of a business. The most obvious scenario we have is that if you have a business being purchased by way of a share sale, generally TUPE will be excluded. So you don't generally need to worry about TUPE in those circumstances. Where you might need to start worrying about it if you have one company buying another through a share sale, and then you start, as it were, mucking about with the new company's organisation and transferring bits of it to other companies within a group. So that brings me on really to look at one other aspect of this, of transferring to another person. And it seems to me one thing that's often overlooked is that if the transfers are taking place within an organisation which is all owned by a single company or a single owner, TUPE will still apply. I think in my experience, that's something which is very easy to overlook. And I guess that a lot of the time you can probably get away, possibly, without anybody realising that TUPE applies. But if you're transferring bits of one business within a group to another company within the same group, it's a thing which is easy to overlook. You might think, well, if we can all do it, if we can deal with the issue with everybody's agreement without paying too much attention to TUPE, do we need to particularly worry about it? Well, that's a judgment for you to make. On the other hand, it seems to me, if you think about TUPE and the effect that it might have on the employees who are affected by the various changes being put into place, it's actually a good opportunity, I think, dare I say it, to get employees on side, to allay their fears about what's happening, and to avoid the potential, and I emphasise the word potential, for employment tribunal claims, because, as I always like to say, you can't stop someone bringing a claim against you, even if it is an ill-founded claim. So that's what I want to say about that. Moving on, let's not forget about service provision change. I appreciate that my colleague Bruce will have dealt with some of these issues a few weeks ago, but I think it's helpful just to touch base on that. So what we're dealing with, I think everybody or most people will understand, is outsourcing, a re-tendering with a client who wants to change the contractor who's been appointed in the first place, and insourcing where the contractor's activity is being taken back by the client. So that deals with that. Let's look at when a service provision change situation does not apply, and I think it's helpful just to flag these issues up. So certainly not in connection with a single specific event or task of short-term duration. The key word there is short-term duration, I think. That's a bit of a movable feast. That's going to be a question of fact for employer and tribunal ultimately to decide. And certainly, just moving on to the next part of my slide, certainly not if the activity is the supply of goods. So putting that in context, for example, if you have a business which supplies goods or manufactures goods and then supplies them, then it will not be an SPC. All right, well, let's move on in a little bit more detail about service provision changes. And I think what I was anxious to do is just to give you some ways of thinking about whether a service provision change will actually apply.
I think this is really useful, Paul, because a lot of the queries that I get on the ground before they come to you as a complaint are always, is it a service provision change? How can I spot it? What do I need to do about it? So is this a checklist that they can go through in their mind?
Absolutely, Marie. So that's my approach. I mean, when I said at the outset, TUPE without tears, I wondered whether it was possible just to take a sort of simple checklist approach to TUPE, and I think it's maybe difficult from someone at my sort of end of the process to think of it in those terms, because I think the difficulty for barristers, perhaps we see all the kinks and difficulties that the law throws up. But it seems to me, going back to my sort of touchstone of thinking about you trying to safeguard employees' rights, whether you like it or not, that a checklist approach is a good way of identifying the problem. So when we come to service provision change, this checklist, for which I take responsibility as my invention, I hope you would find useful. So if you ask yourself in simple terms, is it the same client before and after? And the answer is yes, right? Well, you should be thinking service provision change. Are the services fundamentally the same before and after? Tick yes, you should be thinking service provision change. And then finally, and this is the one that I think is perhaps the most important one and one that's most easily overlooked. Was there an organised grouping of employees whose principal purpose was to carry out the activities on behalf of the client? Don't overlook that. That's what you need to have for a service provision change. And it goes right back to my concentration on this idea of safeguarding employees' rights. So I think if you just move on to the next slide, Marie, I think we've got a little sort of checklist that comes from a recent case this year. I'm sort of offering this as an alternative for you if you don't like my list. If you want one that's grounded in actual case law as opposed to me just ruminating over it.
It's a mouthful, that one, isn't
it? This is an interesting example of actually. If you ever want to look at this case, you just go to bailey.org and search for it. Is a good example of how one employee can be an organised grouping of employees. Okay, so that's often something that makes people think, well, surely that can't be a service provision change. Well, it can be, is a simple answer. And if you need to get a feel for that, by all means, have a look at RINDA. There's no point going into the facts of this case. Let's just look at the list of features which the President of the Employment Appeal Tribunal set out, which really are designed to help us all identify a service provision change. So running through them quickly, you can all read them for yourselves and subsequently study them if you want to. So first of all, identify the service which the company B was providing to the client. I should say the test is based on the idea of company A transferring a service or an activity to company B, as it were. So identify the service which company B is providing to the client. 2, list the activities which the staff of company B performed in order to provide that service. 3, identify the employees of company B who carried out those activities. And just pausing there, you can see this is all leading you down into a sort of corner where the conclusion is reached. Did company B organise those employees into a grouping for the principal purpose of carrying out the activities on behalf of the client? So once again, it all comes back, I think, to concentrate in the service provision change environment to whether you've got an organised grouping. If you don't have an organised grouping, you would like to think you don't need to worry too much. And my little tip here, when it comes to organised grouping, is you need a deliberate organisation by the employer of the employees into a grouping to carry out the activity. Just the fact that you might be doing it by coincidence, or the employees in question might be doing it by coincidence. Example, you may have come across a case called Eddie Stobart and Moorman, which coincidentally was dealt with by my colleague Bruce Frew. There wasn't an organised grouping of employees, even though shift members were carrying out all the work on a particular shift for the client, but that had just arisen by coincidence. The shift hadn't been deliberately organised to do the work of that particular client. So that's it seems to me what you're trying to do is look at things that will help you pick out whether you need to start worrying or whether you can maybe relax, and that's my tip. Does it require deliberate organisation? Marie, you're about to chip in.
I am. I'm just about to say that from my perspective, I have a lot of inquiries, Paul, from people who say are cleaning contractors. That's probably one of my biggest ones. And they'll say, look, I've got 18 sites. I have 2 cleaners who clean on this particular site. This site is being re-tendered. They've always cleaned on that site. They do occasionally clean on other sites if necessary. I don't want to lose these staff, or I do want to lose these staff. What do you think about whether they're assigned or, wholly assigned? And so is your top tip, if you want to keep them, to say they're not wholly assigned, that it's not deliberate, it's just that they've worked there and therefore you can't have them. And or if you do wish for them to transfer, or the organisation can't afford to keep them on and they need to transfer over, to say, well, they've always worked there and therefore on that basis.
I agree, Marie. Those would certainly be, in a typical situation, important factors. That would be an important factor to bear in mind. So if in that sort of context, if the contractor is sending around any cleaner, as it were, any or a cleaner, or cleaners on the particular occasion, and hasn't reserved the activity, as it were, to particular individuals to carry on and turn up day after day, then I think you've got a good indicator of whether you've got a service provision change. Don't forget, of course, that the ordinary provisions of a business transfer TUPE may apply, so you don't lose sight of that. Not wishing to overcomplicate matters, but that is a good little.
It's the most common example I get from caterers, cleaning, that kind of thing.
Absolutely.
Which leads nicely on to your next slide,
It certainly does.
Yeah.
Strangely you should say that. It certainly does bring us on to the next issue. And I think this is one, do you know what? This is the one that causes the most litigation, in my experience, because what happens typically is you get somebody, I like to call them, whether it's a term of art or not, somebody falling in between the cracks. So you get the transferor or transferee transferring a business, or there's a service provision change. They leave somebody off the list, and that person turns up at work. The typical situation must be pretty embarrassing. Poor person, employee who's really assigned, or may not be, who thinks they're assigned at any rate to the undertaking, turns up at the transferor's business on the day after the transfer and wants to carry on working, is told, oh, you're not employed here anymore. Why don't you go off to the transferee? And off they poddle across the city or wherever it may be. Turns out the transferee said, oh, well, you're not employed here. Off you go back to the transferor, and almost inevitably, the next thing is both of you, transferor and transferee, have got a nice employment tribunal claim, and ACAS trying to get in touch with you to early conciliate.
I think that is, just sorry to interrupt you again there, but that's another common issue that I get at first instance, is people coming to see me to say, we've always done this work, suddenly this work has been taken away from us, we've written to the company, or we've gone to see them and said, right, when do we start with you, if they've taken it back in-house or to another provider, and they've been told, well, you don't, do your worst. And as you say, then I suppose it's a claim against both, isn't it?
Absolutely, and you just folks sitting out there to wake you up. Look at it from this point of view, from the disgruntled employee's perspective. Really, they've, apart from coughing up their fees in the tribunal, they've probably got nothing to lose, because most of the time They will have some substance to their case, and they should either have been retained by the transferor, or they should have been retained by the transferee. And one of you is going to have a nice unfair dismissal claim landing, and the liability for that landing on you. So it is a pretty serious situation, and you need to. That's why I'm saying, look, get this right. What you need. Let's just run through quickly my slides, just to sort of implant in people's minds what you need to be thinking about. So think about the way in which the organisation, the transferring organisation, is structured, and the employees' roles in it. I mean, there's no magic bullet here, I'm afraid. I mean, like a lot of these situations, Marie, you'll probably agree with me, it's often pretty obvious who's assigned, but the more complex the deal, the more difficult it becomes.
Yeah, I agree, and I think the most hard-fought cases are the ones where, somebody will come to me and they'll say, look, I'm pretty sure that these people are assigned, and I agree with them, and then the other side will say, well, we wholeheartedly don't think they are, and you say, well, why is that? And they say, they're just not. Well, here's all the evidence, they're just not, and that's the most contested.
I agree with you, Marie, about that, and that's my experience as well. And I think what really is going on here is that I'm sure all of you sitting out there are in reputable organisations, but dare I say it, adopting my cynical lawyer's persona, two things happen here. First of all, employees who aren't really assigned to the organisation get dumped on the transferee. So you get an opportunity to get rid of problematic and difficult employees. And you'll immediately be thinking, well, the employee liability information should flag things up there for me. I agree with you. It should guard against this, but there's a lot of room for things to go wrong. And the second thing that happens is the employer, and this is the more difficult one to avoid, is the transferor may think, well, crikey, I really want to keep one or two of those employees. They're really good, and I could easily deploy them elsewhere within my business. And so when I assign, you as a transferee may get the business coming over without its full proper complement of employees. So anyway, let's just look at the quick run through of what you need to think about. As I say, there's no magic bullet.
Yeah.
So obviously the contract, the job description, that will tell you a lot about what the employee is supposed to be doing. And then to some other issues, where would the employee be required to work immediately before the transfer? And that's an interesting one. None of these things are overriding, bear in mind, particularly when I mention the problems with cherry picking and dumping of employees. The old chestnut of how much time is devoted to particular activities, that's riffing the problem of somebody whose time is split between different activities, one transferring and one not. Another way of looking at it is the value given to the part of the business transferring by the employee. And another really helpful indication is if you can get the information, how the cost of an employee's services have been allocated between different parts of the transferring business. So those are some things to think about. It seems to me you need to. You're only going to get employee liability information on the people who the transferor is saying are assigned. You'll see later on in this talk, when we get to it, I'm suggesting that you pay particular attention to due diligence. You should be, if you're buying a business, so you as the buyer must take the view caveat emptor. You've got the whip hand because you're buying it. You've got the economic power. You can use that to get the information you need. What I'm suggesting is in every single instance, unless it's the most straightforward of situations, one or two employees transferring, you need to start off with a provisional list of assigned employees, as one of the first things you get. And then you need to drill down on the information you're asking for about those employees to make sure that they are properly assigned, looking at the sort of factors I've been suggesting to you. And what you're really doing there is you're safeguarding yourself against the employment risks of three things: cherry picking, dumping, and the prospect that you're going to get that sort of nightmare scenario that I mentioned of somebody polling up on the day after the transfer and saying, I've been told by my old employer that you're now employing me, so please where's my office, my computer, and where do I start?
I think it's interesting this because, again, on the ground, I think we talk about employee liability information, and it as if it all happens. In an ideal world, it all happens where you know where the contract's going, everybody's upfront about things, you get the request for the information, it's provided in full. My experience is that the reason that TUPE is such a nightmare is that these things are not happening half of the time for a lot of companies, so sort of lots of cleaning contracts. So particularly smaller businesses, the bigger businesses who have got their acts together, fair enough, but some of the smaller service providers, certainly, I've had instances where we just don't get any information. We get information at the last minute. Nobody has a contract, or there's no information. On some occasions, particularly in relation to pubs and clubs, we can't get a full list of the staff. Nobody seems to know who's working there. So it is difficult, isn't it?
I absolutely agree with you, Maria.
And that's where people turn up and you say, "Who are you again?" Even when you've had a bit of information written on the back of a beer mat,
Absolutely. The trouble with it is that I think, from what it's all very well me saying all this, but there is a cost to it, isn't there? That you've got to invest time, and there's a commercial imperative which rubs up against that in a different direction. And the other factor you've got is people not applying TUPE, the requirements of TUPE in the way in which they honestly and properly should.
Yeah. And how you enforce that as well. I have a lot of issues about that. I don't know if you go on to talk about that, but I do.
We'll come on to we certainly will come on to that. But my view is, just pausing before we move on to the next subject, is really, I think you've got to get in early. If you're the transferee or in the position of transferee, you've got to use your bargaining power. And I don't lose sight of the fact that if particularly in a small to medium business situation and a service provision change situation, you're probably going to find that the outgoing contractor isn't too keen to talk to you and just couldn't really, give two hoots anymore because they've lost the contract and they don't want to spend any more time with it. I think the only answer to that really is to press the client to use their power to get the information you need. My goodness. How exciting.
Crikey, I think we nearly had an alarm here. We're all right.
I thought it was something I said.
It's looking okay.
No fire then.
God, it wasn't that bad.
Crikey, right, that's your time, you're off. No, right, quickly, come on, Paul, before we have to evacuate. No, we've never had that before.
I don't think there is a fire, but I think Maria and I are going to carry on even if there is one.
Because it's so important to us.
That's how dedicated we are.
That's right.
All right.
Okay.
Let's move on to the next subject. Fire alarm aside, the next lovely issue that I think usually crops up is the whole problem of changing terms and conditions. I don't think I've got any tremendous advice to give you here. You may be disappointed to know. You're just looking at my slide there, statutory novation. I just put that in because what I want you to think about is, I'm sure after Bruce's talk, if you tuned into that, or if you're familiar with TUPE at all, what it basically means is the transferee acquires the contractual obligations and rights attaching to each employee that they had before the transfer took place. As a statutory novation, what that basically means is, from the employee's point of view, their employer changes and they've got the same contract. The crucial part of TUPE that causes all the problems here is for Regulation 4.4. Variation of contract is void if the sole or principal reason is the contract itself. And then you'll see my little bullet point thereafter. Just face it, harmonisation of contracts is going to be problematic.
Well, there you go. Direct
look,
advice.
I'm afraid so. Well, the number of times I'm afraid it just seems to be, I don't know whether people... I guess the problem really is you don't want to work with lots of different terms and conditions and benefits and so on going off into the future. That's the difficulty. I'm afraid TUPE, at least in the short to medium term for transferees, brings that with it. Don't forget, if you need to affect a change to terms and conditions that isn't connected, which isn't because of the transfer, you've got a good argument for saying you can affect the change. So if it's for an unforeseen and unconnected event, I'm talking about things like a major deterioration in the fortunes of the transferee, bringing about a major reason to bring about efficiencies by variation of contracts. That's the kind of reasoning that I'm looking for. So really, you'd be able to turn around and put your hand on your heart and say, well, I would have made these changes in any event. Let's look at a little bit more about what TUPE says about when you can affect change. This has been changed a little bit by the 2014 amendment of the 2006 regulations. So you can make a change with the employee's agreement if you've got economical, technical or organisational reason. That phrase always throws me a bit. And I think you could just boil it down to redundancies or redeployment. The thing I would like to emphasise to you as a barrister is that the thing you need to bear in mind is that second little bullet point I've thrown onto my slide there, entailing changes in the workforce. It requires either a diminution in the workforce, hence redundancies, or a substantial reorganisation, so redeployment would be the other way of looking at it, and a substantial change in the job function of employees. So that would give you an in to effect change. That might come with the TUPE transfer. You could do it with the agreement of employees. And of course, I mean, if the employees don't agree, it could form the basis of it could be a potentially fair reason for dismissal if you get any diehards who are refusing to agree. All right, well, this slide, next issue, rather ominously entitled Practical Considerations. The title of this subject, TUPE Without Tears, I began to realise the more I delved into it that it's a self-defeating title. I don't think you can really. There's no magic bullet. There's no easy way to deal with TUPE. There are ways of thinking about it that can be helpful. If there is a magic bullet, and I full well appreciate that sitting there that you're up against commercial issues, is careful planning. Because there are a lot of issues that you, I'm sure, all very well aware can arise, and it's all too easy to overlook them. My advice really is just set up, at the very outset, set up a realistic timescale to enable due diligence, proper assessment of risks, the election of employee representatives if required. I say that because, of course, you've got the micro business exemption and consultation with the representatives. So just a little bit to say about due diligence and the risk assessment. You've obviously got the obligation to provide employee liability information. That, I think, is never really going to be enough, particularly if you're buying a business. I mean, you've got the basic information, identity and age of the employees, particulars of employment, the bare minimum, disciplinary grievance issues, tribunal claims, information about collective agreements. I mean, it takes you a long way, but there's a lot more you might want to know, particularly, as I say, if you're buying a business. I've just given some little examples of what they might be, and enhanced redundancy payment schemes. That could really ruin your business transfer. Discrimination issues lurking there underneath, like equal pay issues, for example. That might be a major risk issue in a business that's not been up with its equality and human rights issues.
I've had a couple of those. I've had a couple of cases where I've dealt with companies on a TUPE matter, and we've got the employee liability information, and in one team alone, you've 2 women, 2 men doing the same job, but both men got paid £5,500 more than the women. And although I didn't want to make a big deal of it, I sent an inquiry back just saying, can you just tell me the issue?
Well,
is there an issue here? Seems to be the same role. They've been there the same length of time, but they're being paid differently.
Well, you've got to do these things, because obviously the liabilities could really ruin the business deal and make it and reduce the value of it.
And also, if you've got unhappy staff who are shifting over as well,
absolutely,
it just becomes a minefield.
And the starting point is anybody who's told, well, hi there, you're in a few months your employer's going to be changing. You're not naturally going to take that as good news, are you?
Well, I don't know. It depends whether you like your existing employer or not.
As a general rule, I don't exclude the possibility you might be overjoyed.
What was their response to the question you raised? Yeah, it's interesting, that, isn't it? The response I got back was, if I'm being honest, was that the men had negotiated harder at pay increased time. which interested me a lot, but didn't go very far in allaying my fears about equal pay, I have to say. But in my experience, that does happen. I think, 9 times out of 10, that's happened to me a couple of times where they've said, well, just fought harder for it.
Well, it's a good example of the sort of issue that might not, that's not going to arise from the employee liability information. If you drill down into the information and look at, I've given a sort of list of stuff, as it were, you need to be thinking about. That demographics issue would be one example of what I'm talking about. So, things that you might want to know about are the ethnic breakdown, the breakdown in terms of sex, the number of part-time employees, salary bands, and so on. So
you're not going to get it. You don't get it though, do you? I think that's the problem.
It depends, doesn't it?
Yeah.
It depends on how much bargaining power you've got.
It does.
If nothing else, it's something for you to think about and keep your antennae switched on with regard to, because if you are switched on, maybe you can see it coming your way.
Right.
So next question is, how do you protect from these risks? Well, obviously, if you're doing your due diligence, however much time you've got and however much investment you can throw into it, obviously that can affect the price for the purchaser of the company. Equally, you can protect yourself by way of warranty. So, there's just some simple ones. Might be, you could say that all the, going back to my issue of who's assigned, you could have a warranty that the employees listed in the warranty or in a schedule attached to the warranty will transfer, and that no other employees will be transferred. Well, you could have a warranty to the effect of everybody's been informed and consulted. What's the difference between a warranty and indemnity? An indemnity really is just saying, on a warranty you basically sue for breach of contract, so you might wind up in the civil courts. Hopefully not, you would sort it all out before it ever got there. And indemnity is actually guarding against a specific risk. So it would be providing that the transferor is protecting you against the liability of unfair dismissal claims, or for protected award in the event that somebody hasn't complied with their obligations to inform and consult. Okay.
It leads nicely into your next slide.
Indeed it does. Indeed it does.
Yep.
This is the old. Once again, this is the one where employers often fall down, because this is where commercial realities rub up against TUPE, don't they? Because what the regulation says long enough before to enable the employer of any affected employees to consult the appropriate representatives, almost invariably, in my experience, that not enough time is left to do all the things you need to do. And I think it's important to bear in mind that when you're looking at consultation, it's actually consultation with a view to seeking the employee's representative's agreement. Obviously that's if you're planning to affect any changes which affect them. Another little thing just to throw out there for you is, bear in mind, affected employees is wider than just employees who are assigned to the organised grouping that's being transferred or that's carrying out the activity in a service provision change. And I think it's helpful to bear in mind Regulation 13A. This is a nice little provision if you're dealing with small. And I think this really is the most. The fact of the matter is that I think this is a real boon, because the need to elect employee representatives is a bit odd when you've got 3 or 4 employees. Thankfully, we've now got Regulation 13A. I think it's less than 10 employees. You just inform and consult with them all.
I don't think any of us ever did that. Anyway, maybe I've just been getting away with it for 15 years before that came in, but. If I've acted for companies who have got 5 staff, we've not gone through the rigmarole of electing people. We've just spoken to them directly.
I think that was the right.
It's common sense, really.
I think that was the right judgment to make. But in case you're worrying about it, I think it's it's one that you're sort of skewered by that in the past, I think, and at least you've got a way out now. Now, my sort of final issue that I want to throw up for you is this. It's headed rather ominously, proper handling of employment relations issues. And I come back to this point, don't treat the election of employee representatives and consultation as a hoop to be jumped through. I think, as an employment lawyer, that it's a real opportunity, if you get it right, to get your employees on board, and aside from all the sort of hard legal issues, just to minimise, from a sort of soft power or soft management point of view, how you can sort of, as I say, allay employees' fears, keep them in the loop, and get everybody on board with the changes, and hopefully get them enthusiastic about what's happening, particularly if you're the transferee or transferor in terms of employees you've got left. So, as I say, make sure consultation begins in good time. If you can't, try and make it a genuine dialogue.
It's all about communication, isn't it? When I often act for claimants or individuals, and I have done all my career. And namely, the one thing that they complain about when they come in to see me, before they even bring a claim and it gets to tribunal, is that they feel aggrieved. They've not been corresponded with and communicated with properly about things, and they feel like they didn't matter. And that actually pushes them into bringing claims, when actually a good level of communication would probably have just seen it off. They wouldn't even be coming to see me.
I absolutely agree with you, Marie. I mean, I think we'll be saying this until the end of time, really, frankly, because it's just something that is it's something that's just so important to emphasise in these situations, and I think that is the way to do it, and to try and minimise your risks going forward. And there you go, some exciting contact details.
Sorry, I'm having to tie it up because we've run over a little bit. Well, we're up to 45 minutes, but I know that Richard will be getting touchy on his end there, won't you, Richard?
Always, as always.
So I don't know if anybody has any questions then. I mean, Richard, are you still recording, or do you